For the last 10 years or so, I have been engaged in a series of studies on international criminal law. Though it's not my sole focus, I look at things like rule of law reconstruction, transitional justice, and peace building in post-conflict states. I have been very interested in the interaction of international criminal justice with these separate practices and disciplines. I suppose I would characterise myself as a critic of international criminal justice, or the ICC, though at this point there are very few people working in the area who wouldn't classify themselves as critics. All that really matters at this stage, I suppose, is how far on the spectrum of criticism you exist. Those days of euphoria and overwhelming support for international criminal justice and the court in The Hague have long since dissipated. My journey towards my present studies on the ICC and the International Criminal Justice Project overall probably start with my PhD, which was on the special panels for serious crimes in East Timor. These panels started up in the early 2000s after the Indonesian withdrawal from East Timor. And at the time they marked the high water mark for international criminal justice in terms of its support, in terms of the optimism that surrounded it. And in the course of these studies, I began to look at both the special panels for East Timor and the Special Court for Sierra Leone, and then I widened out the study to consider the parallel hybrid courts that were ongoing in Cambodia and in Kosovo as well. And in the course of these studies, I became quite concerned about the impact of international criminal justice overall on the domestic state. Not merely its politics and national attitudes to human rights, but also their impact on national judiciaries. One of the ideas underpinning the hybrid courts, and indeed one of the ideas that probably underpins the complementarity regime of the ICC, is this idea that international criminal courts can catalyse positive change in the judicial systems of courts, of states rather, where it is working. But what became apparent to me in my consideration of the hybrid courts was that this notion of a judicial legacy was largely illusory. The actions of international judges and prosecutors and defence counsel in East Timor, in Sierra Leone, in Kosovo, often left a largely illusory legacy towards domestic criminal justice systems. And once I'd finished my PhD and my studies in this area, I began to ask some serious questions about international criminal justice. I became concerned that international criminal justice is more concerned for its own institutional self-preservation than it is for the judicial systems or domestic structures in the courts to which it is attached. And this got me into quite a sceptical position about the efficacy and the legitimacy of the International Criminal Justice Project overall. After my PhD, I wrote a book on rule of law reconstruction and transitional justice. And in the course of this study, which examined how processes of international criminal trials, domestic criminal trials, truth commissions, reparations programs, etc., impact on rule of law reconstruction in domestic states, it became quite apparent that international criminal justice, and in particular the ICC, was very ill-equipped both organisationally and in terms of how it organised its own priorities to leave a positive judicial impact on states concerned. One whole chapter of the book dealt with the complementarity regime of the ICC, in particular Article 17, but also Articles 18 and 19 and the preamble. And in looking at this, it became apparent to me that the ICC had very little concern for bolstering the judicial capacity of states where it was undertaking investigations. Though the preamble and Article 17 appear to place a great onus on the court to ensure that domestic states are able to undertake their own prosecutions, what became apparent to me in this section of the book and in a series of later articles was that the ICC has a far greater concern for its own institutional self-preservation than it has for bolstering the judicial capacities of domestic states. The concern obviously being that the stronger domestic courts judicial systems become, the less likely they will be found to be either unwilling or unable under the terms of the Rome Statute. In particular, I became quite critical of the whole concept of burden sharing, which now seems to underpin the prosecutorial strategy of the ICC. While it's clear that the Rome Statute permits self-referrals by states on certain occasions, the court overall has adopted a much more proactive policy of burden sharing in seeking to relieve states of their domestic duties to prosecute and assuming it at the global level before The Hague, leaving open the question of what potential impact it can have on domestic states. Does the ICC actually offer anything to the states where it's concerned that makes them more likely to be able to deal with mass atrocity or serious crimes in future? My studies of these issues made me somewhat skeptical about the court. It's quite easy to be skeptical about the ICC in many respects, considering its rather poor track record in the last 10 years, its slow procedures, its obvious frailty in dealing with the major powers or with recalcitrant rights-abusing governments. I'm not merely concerned with this frailty, however. I am quite concerned with the ICC's almost total lack of interest in leaving domestic judicial legacies in the states concerned. And this lack of interest has sort of spurred the course of studies I'm engaged in at present, where I'm looking at the role of the ICC as an actor within overall global liberalisation. We are living in an era where the International Criminal Court is coming under strong critical fire in a number of respects. Some people simply want to make the procedures of the ICC better, to make its power stronger, but there is a strong critical current emerging, most notably here from the University of Liverpool, where Dr. Christine Schwabel has been very active in critical approaches to international criminal law. And these people in a more critical vein question the overall legitimacy of the international criminal law project. I wouldn't class myself as a rejectionist of international criminal law, and I do find some of the criticisms of it to be somewhat exaggerated to the extent that it is labelled imperial or hegemonic or simply an agent of the West.